Welcome, everybody. Excited to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center, and happy to have you in class today. I am here with one of our top scholars in constitutional law, Tom Donnelly. Tom, how excited are you for this class today?
Hello, everyone. I am very excited. It's a good class on both nuts and bolts, but also, as always, on constitutional text and history.
We love it. We like to get the how stuff works, how the court works. That's what we're going to do today, and dive into the like Tom said, dive into the Constitution. But we're also going to add a little quiz show to this as well, because we like to have a little bit of fun with it as well. So in the chat, if you want to play along, you can do it on YouTube or in the chat. Answer these questions, and you can do like 1 and then the answer, 2 and then the answer, and 3 and the answer. But I'll pretty much figure out which one you're talking about. So here's your pop quiz, and don't worry, pop quizzes only are impressed with any of the answers you get correct. There's no negative if you get something wrong. But the first question is, how many justices are on the Supreme Court? So as of right now, how many justices are on the Supreme Court? First question. I love that Carrie was already diving in and answering all of these. Second question, and I fixed this, Tom, so it wasn't a two-parter. Who nominates the justices? So pay attention to the word. Who nominates the justices or potential justices? Third question, what are the 3 levels of the federal court system? I think that one's a little tricky, a little hard, but we will go through all the answers today. And then finally, the zinger of the class, and always a shocking answer, what are the qualifications for justices? So feel free to put that in the good job, everybody. You are playing along lovely in the chat. It's always fun to do quizzes. And Tom, I like to start, when we talk so much about the Constitution, we talk so much about teaching the history, but what we love more than anything at the Constitution Center is telling the story about people. So let's start with my favorite part, the class photo of the Supreme Court today. So Tom, how many justices are on the Supreme Court today?
There are 9. And there they are.
And there they are. And they're clearly not organized by height, because Kagan is definitely a little bit shorter than everybody else in the back row. So walk us through how they're lined up.
Sure. So they are assigned based on their seniority on the court. So this is known as the Roberts Court, named after that person right there in the middle, Chief Justice John Roberts. He's the Chief Justice of the United States, added to the court by President George W. Bush in 2005. And then if we go right next to him to number 2, that is the most senior justice on the court, Clarence Thomas, added in 1991 by President George Herbert Walker Bush. And then you flip to the other side to number 3, that's Justice Stephen Breyer, added by President Bill Clinton in 1994. And then you flip to number 4. It's kind of a weird Rube Goldberg-like experiment where all these justices are sitting. But number 4 is Justice Samuel Alito, who was added by President George W. Bush in 2006. And you flip all the way to the end of that first row to number 5, Justice Sonia Sotomayor, added by President Obama in 2009. And then we flip to the back row, where we get to number 6, Justice Elena Kagan, added by President Obama in 2010. And then the final 3 justices were all added by President Trump. Number 7 is Justice Neil Gorsuch, added in 2017. Number 8 is Justice Brett Kavanaugh, added in 2018. And then the final justice is number 9, Justice Amy Coney Barrett, added in 2020.
So that is awesome. And Justice Gorsuch has done a lot of our classes, as well as Justice Breyer. So it is really fun to have them join us for class and talk about the role in the courts and their experience in life as well. So Tom, Article 3 of the Constitution, I have to be honest, there's not a lot in there. There's not a ton in Article 3. So can you tell us how it spells out, not just the Supreme Court, but also how the lower courts, how's that spelled out? And does it say in there that there are supposed to be 9 justices, or is it leave it up to somebody else to figure out?
It's a great question, Curry. Article 3 leaves many questions unsettled and to be filled in by Congress and by Supreme Court practice over time. So I'll drill down into both of those points as we get into Article 3 of the Constitution. So Article 3 lays out the third branch of government, the judicial branch, which is headed by a single Supreme Court. And so as we get into Article 3 here, a lot of the text can be a little more technical, but we'll try to draw out some of the really big ideas here as we go through. And so we notice first that the Article 3 begins with what we call a vesting clause. So the judicial power of the United States is vested in one Supreme Court. And here's really important language after that. And in such inferior courts as the Congress may from time to time ordain and establish. So what we see here is that the framers really, they wanted to have a Supreme Court, but they wanted to leave a lot of the details of how the Supreme Court would work, what it would look like, and how the federal court system as a whole would work and what would look like to Congress, to politics, to how they decided to fill in the details over time. And so this leaves a ton of power to Congress to shape what the federal judiciary and what the Supreme Court will look like. For instance, Curry, you're right. There is no part of the Constitution that says how many Supreme Court justices we're going to have. And so that question alone, it's left to Congress. Originally, we had 6 justices. Over time, we've had as few as 5 or as many as 10. And Congress has altered the size of the court 6 different times. The last time they did it was in 1869, where they set 9 justices, what we have today. And interestingly, that was a gift by a Republican Congress to President Ulysses S. Grant when he became president. So when he became president, they created a new Supreme Court seat for him to fill. But the Article 3 leaves other key questions also up to Congress, including the shape of the jurisdiction of the federal courts. This is just a fancy way of saying that Congress has a say in what sort of cases federal judges can or must hear. And then finally, this last one really blew my mind when I got to law school and studied this closely, but it's that many of the details of the federal court system as a whole are left to Congress. So how many federal judges we're going to have? How many different layers of federal courts? How many district courts? How many courts of appeals? And so many key features being left to Congress. And so that's one of the things we really want to pull away from Article 3, Section 1. The other big principle here, Curry, is the principle of judicial independence. And so here what we see in Article 3 is that judges, federal judges, including Supreme Court justices, hold their offices for life. So quote unquote, during good behavior. We call this life tenure. And what this means is that it creates an independent judiciary. And so once judges become federal judges, the Constitution tries to keep them from being controlled by the political branches, from the elected branches. So, they can't be fired, they can't be fined, they can't be otherwise controlled by other branches of government. Again, the big principle here is judicial independence. The key idea is that we want judges to be independent enough that they can check the elected branches. So remember, for the founding generation, what were they really, really concerned about? Well, they were concerned always and paranoid about different parts of the government having too much power, but they were especially concerned about a too powerful Congress. And so they wanted to make sure that we had a strong enough federal judiciary to maintain checks and balances and check the different elected branches if they seem to be abusing their power. Where did they learn this? Well, they learned from their own experience in colonial America. The royal judges served at the pleasure of the king, served the king, listened to the king. If the king didn't like what the royal judges were doing, he could fire them, and he did. And we wanted to make sure with our new Constitution that that wasn't going to be our system. So we wanted an independent judiciary.
And I want to go over a couple other kind of vocabulary words that we hear flying around when we think about the courts. But 2 clarifying questions. So when Ulysses S. Grant was number 10, when the next person left the court, did it go back to 9 or did they keep it at 10 for a while?
Oh, no, it's we got 9. We got 9 with Grant. It got to 10 with Lincoln. It got to 10 with Lincoln. They got rid of 2 while President Johnson was president and then gave 1 back when Grant became president.
Got it. Sorry, math not as quick when I have a head cold, sorry. Second question, who was the first, we're all having a debate in the chat, who's the first justice to be sworn in?
The first justice sworn in, I mean,
we went with
it
John
must have been
Jay,
the entire package. It must have been the entire package of Washington justices. I mean, perhaps Chief Justice Jay, though I'm not sure, technically.
Okay. Got it. Okay, we're making guesses in the chat around this one. Now, as we dive into kind of looking at what's the role of the courts. We also hear things, we hear judicial independence, but we also hear words like judicial review. So just to make sure we're all clear and on the same page, can we go over judicial review? And what I feel sometimes is very connected to that is judicial supremacy. So can you walk us through these different words, how they all interact, and then we'll dive into how the courts work?
Yeah, so the core power from a constitutional perspective of the Supreme Court and the federal courts is judicial review. And so this is the power to review actions and laws passed by the government. That's the simplest way to understand it. Now, it's important to note that there is no specific part of the Constitution that grants judicial review to the federal judiciary or to the Supreme Court, but it's part of there are strong arguments from the Constitution's history and structure that it is there. And we'll get into some of those later in the lesson, but that's the core power of the federal courts and the Supreme Court from a constitutional perspective is judicial review. Judicial supremacy is an additional set of debates over the broader power of the courts to settle constitutional meaning. So judicial supremacy refers to the idea that the Supreme Court is the final voice on questions of whether or not actions by the national government or state governments are constitutional. Those who believe in judicial supremacy believe that the Supreme Court is the final, ultimate interpreter of the Constitution. But there are many scholars, many political leaders, even many justices who disagree and say that other constitutional voices are out there in the system to challenge the Supreme Court and its own arguments about what the Constitution means.
Awesome. So a question from Gloria, and we talked about this in the last class, Gloria, so I was right there with you. Knowing that 9's not in there directly, Gloria wanted to know, is adding members to the court, packing the court away to subvert judicial independence? And that the fear of that is being talked about today. So that was the question I had for you, Tom, is how much do we talk about the Article 3 and looking at what Congress has the right to do? So how many? So how many federal judges, how many courts of appeals, how many districts? How long has the system been set up to have either 9 or the structure that we know today in the lower courts? And is that still in debate today? Is this the right structure?
Yeah, so 9 has been, just as a matter of custom and norms, has been the number since 1869. So it's been a really long period of time. But there have been debates over the size of the court throughout the court's history, beginning with, the founding generation all the way up through until today. Sometimes these debates have had to do with more, sort of less raw politics and more just the nuts and bolts of how the court's going to work. So over time, the seats of the justices were closely connected to geography. And so over time, we added different seats to the court as more parts of the various territories became states. And so sometimes it was a geographic question, but over time, it's also been arguments over using Congress's powers as blunt checks when the Congress and the political branches think the Supreme Court has gotten something wrong. And so there are debates between scholars, political leaders, et cetera, over how much independence we want the courts to have, how important that norm of independence is, versus how important it is for the political branches to be able to check the courts. And this is just an ongoing political debate that has crossed ideological lines throughout American history.
Awesome, thank you. Now, diving from the Supreme Court, you talked about getting all the way to the Supreme Court implies that there's a way to get there. And so how, and I guess maybe the question is, how do the cases go into the court system and how do they work their way up the court system? And that really helps to spell out the lower courts for us and how the structure is set up. And you just talked about geography being a big part of it too.
Yeah, and so this is a great graphic right here. And so it shows you the 3 layers of the federal court system. The lowest level is the district courts, the middle layer, the courts of appeals, and the highest level, the Supreme Court. And so, if we're thinking about a constitutional case, maybe it might be worth it to just walk through sort of the life cycle of a case and how it gets to the district court and up to the Supreme Court. And so court cases, constitutional cases, often begin with just a single American arguing that something the government has done is unconstitutional. Something the government's done to them is unconstitutional. It could be a law is inconsistent with the Constitution, could be a regulation, it could be an arrest. It's just an action of either the national government, state governments, town council, president, governor, This is a way where for ordinary Americans to come to the courts and argue that what the government has done is unconstitutional. And so many cases begin with we, the people, or even me, the individual. And so these cases begin, if we're walking through the national court system, in the district courts. So this is the lowest level of court in the federal system. There are a total of 94 district courts in the United States spread throughout the nation. So they're organized by geography. And this is where nearly every case starts and also where most of them end. So the bulk of the actual work that's being done in the federal court system is being done at the district court level. If we're talking about a case in the district court, a single district court judge presides over or manages the case, and the case is decided by either a judge or a jury, and ultimately someone wins or someone loses. And so this is the initial level, that's the district court level, but the person who loses at the district court level can then appeal the case. And so when they appeal the case, it then hops up to that next level of court, the Court of Appeals, which is probably appropriately named. This is where the appeals are going from the district court to the Court of Appeals. And this is the intermediate layer of the federal court system. And if someone appeals their case to this court, the judges then have to decide it. They'll usually decide it initially by a 3-judge panel of these circuit court judges. And that circuit court then has to say either the district court got the case right or they got it wrong. And so the person who wins at the lower level could win or they could lose once they get to that circuit court of appeals level. And altogether, there are 13 circuit courts of appeals. 12 of them are organized geographically. As you can see the list here, this is a great map. And then there's also the Federal Circuit Court, which deals with a certain set of cases, mostly having to do with patents and copyrights. And so that's the Court of Appeals level. An important feature of the Court of Appeals is that they don't have control over which cases they're going to take. If you appeal to the circuit courts of appeals, they have to decide your case. And so that's sort of what happens there at the intermediate level. And then finally, in order to get to the Supreme Court, the loser at the Circuit Court of Appeals level files a petition to the Supreme Court asking the court to review their case. This is called a petition for a writ of certiorari. It's just a fancy Latin word. Lawyers love Latin. But in the end, really what this means is that a party has lost in the Circuit Courts of Appeals and they're arguing to the Supreme Court, you should review our case. And the Supreme Court's special in this sense because unlike the district courts and unlike the Circuit Courts of Appeals, the Supreme Court ever since 1925 has virtual total control over which cases it's going to take. It has control over its docket, so it could say no. It could say, no, we don't want to review their case, that particular case. And so what this sets up is the Supreme Court is not there to decide every case. It's not there to right every wrong, but it is there to select a certain number of cases that are appropriate for review at the Supreme Court. How do the justices do this? They get these cert petitions, they review them, and then if 4 of the 9 justices decide they want to hear a case, it goes onto the court's docket and the court will decide it. So that's less than a majority, but it's 4 justices. We call this the rule of 4, appropriately enough. But that's ultimately how a case gets on the Supreme Court's docket. But what's notable here, Curry, is it's really very, very, very few of the petitions are granted. The court says no to virtually every petition that comes before it for review. The court every year will get about 10,000 petitions for a writ of certiorari. In the end, they will decide between 60 and 70 cases through oral argument all the way through to opinions. So it's really, really hard to get your case heard by the Supreme Court.
So it makes complete sense how obvious and transparent the courts are. Their process is very systematic. It's very clear. It makes total sense. And that you want that so people can see this is how the courts work. It's the same way for everybody, all those pieces, or at least that is the goal of it. But I also find it really rewarding as well when it's just direct, like the rule of 4. It literally means 4 of them. But the other question I have around this is they only pick 60 to 100 out of up to 10,000. That's a really small percentage. What are the ones that get 4? What are the ones that they're really looking for and saying these are the ones we need to pick because this is what our job is to really focus on?
Yeah, so there are 2 really big criteria that they look to. One is sometimes it's a case they just think is of national significance and it's time for the court to decide it. I would say usually where this happens is if a lower court declares an act of Congress unconstitutional or important regulation advanced by the executive branch is unconstitutional, there's a pretty good chance the court may take that and say that's something of national significance. We really need to weigh in on that before there's any sort of final decision on the constitutionality of that law or regulation. But Curry, most of the cases the Supreme Court grants have to do with settling disputes in the lower courts. These are called circuit splits, but this is where different lower courts look at an issue and decide it in different ways. And so the Supreme Court there looks at it as its role, not so much to right every wrong that's been done by a lower court, but to ensure that the law is applied the same way throughout the nation, especially the Constitution is applied in the same way throughout the nation. And so they'll take cases where the lower courts disagree and try to set one rule that all of the lower courts will then need to follow to ensure that if you're an American and you're in any particular state, that you'll have the same rules apply to you.
Awesome. Okay, so a couple clarifying questions on the appeal process as we go through. So Mike wanted to know, can the winning party who may be unsatisfied with the amount of the judgment also appeal to the higher court?
So yeah, if you did not get the relief that you thought you wanted, you didn't get the full relief that you were asking for, you can then appeal similarly. And so it's not as though it's like, it'll often be the case for, in a particular case, parties will win on some issues and lose on others. And so it's not quite as stark as I laid it out there. But basically, if you're unsatisfied, you didn't get what you were calling for in that particular level of court, you can then appeal.
Got it. Now, second question, James wanted to know, can the loser appeal for any reason whatsoever, or are they specific reasons they need to cite? So as they're laying out their cases and going up the court system, do they have to stay with the same plan and the same tactics?
So generally speaking, yes. If you do not raise a particular legal claim, for instance, in the district court, you could be the higher courts can say that you have effectively waived that claim. There are exceptions to that, and that's more of a prudential judgment by the courts. But generally speaking, when you're putting your complaint, it's called a complaint as you're in the district court, you're going to put down all, sort of your full statement of what happened and all of the ways in which you think you should get legal relief. And so they really read like a menu. There's less reasoning and sort of more issue spotting in those complaints, but you want to have everything in there at the lowest level at the beginning. So then as you appeal up, you can then refer to those legal claims as you as you continue to go on. And so that particular legal claims aren't waived early on.
And this is what I find so fascinating about study Brown versus Board of Ed, how they systematically did that at the lower courts across the country and kind of weave their way up. And it's just a brilliant strategy. So on that, let's talk about what does the court do? So they took it. Okay, you're one of the 60 to 100 that get through to the court and you're going to be listened to. What's the process from there? How does it go from that point on?
Yeah, so there's going to be sort of 3 different steps from there. Now, I love it. We've had Justice Breyer so many times at the Constitution Center, and people always ask him, what is it like to be a Supreme Court justice? What sort of qualifications, what sort of qualities should you have? And he said, you have to like to read a lot, because most of his job is reading. And so the first thing that the justices are going to do as they get this new case is that they're going to have a pile of legal briefs to read. And so these are just little books that are written by the different lawyers in the case. You could see a great picture of them right there. And so the justices are going to spend a lot of time digesting these writings and really trying to figure out what are the different sides arguing, what are the different things I need to take into account. And so this first level is you get all the briefs and you read all the arguments. From there, then, the Supreme Court holds oral argument in a case. And so that is the opportunity for the lawyers, for the parties to stand up and make their best arguments before the Supreme Court. And other than during COVID times, in person. And what's amazing is if you're in the Supreme Court room, you could see the lectern that the advocates speak at it's so close to the justices. Like the room itself is so grand, but the conversation is so intimate in that sense. And so this is the opportunity for the advocates to make their best arguments, and importantly, to respond to the questions of the justices. The justices can clarify certain things and really try to, weigh the arguments on each side, and maybe sometimes also how different outcomes might affect the law in different ways. But oral arguments, it's under 2 hours for a case. So the advocates don't have a ton of time to make their cases. So that's oral argument. And then finally, after oral argument, the justices will meet in what's known as their private conference. And so this is where the justices are going to take votes. and discuss the case. It's kind of an amazing process, and there's no one else allowed in the room. There's the room right there. That's the room where it happens. And only the justices are allowed there, no clerks, no assistants. And so this is where the justices will sit down and for the first time after oral argument, really say how they're going to vote and why. And so there's a formal process here through which they do that. The Chief Justice will vote and say his piece first, and then they will proceed down the line by seniority. And so with that, I love this. Justice Breyer has told us that there are some norms for those sorts of conversations to ensure that they sort of remain fair and civilized. Because remember, these are really smart people who know a lot about the law, who often have strong views about how to read the Constitution, what the Constitution means. But what Justice Breyer tells us is that these conversations, they're always respectful, always civil. And so two of the key rules that he says for these conferences, two of the key norms that they follow, one is that no one can speak twice until everyone has had the opportunity to speak once. And so they could always feel as though they are treated fairly as part of the conversation, have a chance to say their piece. And the other is that the justices aren't sitting there waiting to pounce on their people who disagree with them. Instead, they listen respectfully, they take notes, they try to really hear what their colleagues are saying. And so even if in the end they disagree, and often they do, we know that they do, that at the very least, the conversation is responsive to the substantive arguments made on each side, and that the conversation remains respectful, even if at the same time it is rigorous and often difficult.
Awesome. So everybody's excited about talking about norms and their behaviors. And I love having this conversation. I will send everybody out the link to Justice Breyer giving that breakdown, Tom. And it was so good for you to share this. So there's rules of the court, and we just went through so many process rules. And then there's norms of behavior, which are like a shared agreement to be able to do something as a community. And I love that kind of differentiation between the two. But everybody wants to know who opens the door. Emily, had the right answer in the chat. Good job, Emily. But a fun norm of the room is who opens the door if somebody knocks.
So it's the junior justice. So it's only the justices in the room. If someone's at the door delivering food or legal briefs or whatever, knock on the door, the junior justice has to answer the door. What's pretty funny about this, when Justice Breyer tells it, is he was the junior justice for over 10 years. And so he had this job for such a long period of time. And that's just an example of sort of the traditions and norms of the court.
Which we love, the humanity of it too. And then another norm that Fred asked about earlier is, and I love this sketch because it reminded me of Fred's great question, how come they do it live? And they did audio live during the pandemic, but why don't they ever televise the court?
Well, the court itself is a very slow-moving institution. And so one of the great innovations during COVID, at least from my perspective, was getting the audio of the argument out there live, which they hadn't done in the past, but they did with COVID times. But the court is concerned about the possibility of grandstanding. They don't want to start, I think they look at institutions like Congress and what happened with C-SPAN, and they're concerned that it might end up similarly affecting their own proceedings. And so for them, they're really small C conservatives. And, in the end, part of, as they view it at least, tending to their institution is not to change norms like that. In that sense, the Supreme Court seems a little more old-fashioned than the other branches, maybe moves a little slower. The flip side is, advocates of, televised arguments is just that the American public could really benefit from seeing how this actually plays live and, be able to see how it happens and actually be in the courtroom. And so concerns about transparency press in the other direction. But this is a debate that has existed for decades upon decades.
And it really is amazing to go to any court procedure and to sit in the audience and watch. We know that one of our students, Warren, it was actually in the procedure himself, and he had a case in front of the court. So it's super cool to have you in here. James wanted to know why the arguments are so short. Why are they only 2 hours?
Well, that hasn't always been the case. I mean, that is another practice that it's changed over time. But I think from the perspective of the court, they know that you can have endless arguments. But they're hoping that 2 hours is kind of long enough that it allows each side to really air their strongest arguments, forces them to be precise in what they choose to emphasize and what they don't. It also gives the justices enough time to sort of tick through the questions they have after reading through all of the briefs without getting bogged down and going on for too long. But yeah, I mean, it feels kind of arbitrary that it's that short. But, that was part of Chief Justice Rehnquist, who was the Chief Justice before John Roberts, really tried to administer the court in a more efficient way than some of his predecessors did. And I think that that's part of the norm that grew out of Chief Justice Rehnquist being the Chief Justice for as long as he was, for a couple decades, almost two
Awesome.
decades, 2 decades.
Now, real quick, walk us through kind of the opinions of the court. And then we also have a question about the Judiciary Act of 1789. So I thought that would be fun to dive into at the end.
Sure. So we have oral arguments, we have conference, and then the justices have to write opinions. And so we always urge people, if it's a case you care about and there are multiple opinions, read all the opinions. It'll give you a sense of really the range of arguments that were available in a case. We know there's going to be a majority opinion, which is usually just a single majority opinion written by a justice, which is going to say how the court's decided the case, how it's going to come out, and also the court's reasoning for why it decided the way that it did. Then we also know that in a lot of cases, one or more justices who disagree with the majority will write dissenting opinions. And so they'll do some combination of saying, 1, how they think the case should have come out, 2, why, what their reasoning is, and 3, why they think the majority got it wrong. And then finally, even within the majority, certain justices may write what are called concurring opinions. And so these are people in the majority who agree with the outcome of the case, may even agree with the court's reasoning as a whole, but may have different thoughts about how to analyze the issues, maybe some of the consequences of the opinion, maybe responses to the dissenting opinions, et cetera. But basically, the justice has something else they really feel like they need to say, and so they write concurring opinions. Over time, what we know from American constitutional history is that sometimes the dissenting opinions or the concurring opinions prove to be more important than the majority opinion. That sometimes the dissenting opinions, concurring opinions, are so persuasive, will provide such an interesting framework for analyzing issues that the court will end up adopting them as future majority opinions.
Awesome. So always read all the opinions, not just the majority. They're really important. So real quickly, Tom, you probably want to bounce from Federalist 78 to the Judiciary Act of 1789, but go for it. We've got like 2 minutes.
Yeah, so I mean, the last thing to note, Curry, is just to return to the power of judicial review. So judicial review is, again, that big power that the Supreme Court and the federal courts have to declare whether a law or a government action is constitutional or unconstitutional. If you want to see the fully formed arguments for why judicial review exists and the role that it plays in our constitutional system, the 2 key sources are Alexander Hamilton's Federalist paper essay number 78, and then also the Supreme Court's opinion in Marbury versus Madison in 1803. Traditionally, the traditional way that Marbury is taught is that it in a lot of ways establishes the precedent for judicial review, for the Supreme Court to exercise the power of judicial review. But both Hamilton and Marshall advance important arguments for why judicial review exists and how it's consistent with the Constitution's text, history, and structure. Again, there's no particular clause of the Constitution that says that the judiciary has the power of judicial review, but both Hamilton and Marshall root that power in the foundation of popular sovereignty, so that the Constitution is rooted in rule by we, the people. What do the people do when they establish a constitution? They lay out certain powers of government. They distribute those powers to the different branches. And so each branch of government is responsible. They take an oath to the Constitution and an oath to maintain those particular limits. With the judiciary, again, through Article 3, is given the judicial power of the United States. So at the time the Constitution was framed and ratified, we already saw judges exercising the power of judicial review. So that would be seen as part of the power that judges are going to have. But furthermore, judges themselves take an oath to uphold the Constitution. The Constitution, because of Article 6's supremacy clause, is the supreme law of the land. And so for both Hamilton and Marshall, when the courts are exercising judicial review, what they are doing is they are enforcing the American people's constitutional commands that they wrote into the Constitution's text itself, and ensuring that other branches of government aren't exceeding their powers. And so judicial review becomes a check on the abuses of the other branches of government, ensuring that they're maintaining within the limits of power that the American people granted them in the Constitution itself. That's the core of judicial review for Hamilton and for the Marshall. It's a way for the courts to ensure that in the end, here in America, we, the people, through our Constitution, remains the supreme law of the land.
Awesome. And then real quick, Judiciary Act that really sets up how we see the courts starting to form after Article 3, correct?
Yeah, so this is a reminder that, again, Article 3 is leaving so many of the details of our federal court system to Congress. What's one of the first things the first Congress does? It sets up the federal judiciary. And this is this important Federal Judiciary Act of 1789. It's setting up the Supreme Court. It's setting up the federal court system. It's telling us sort of how the different layers of the federal court system are going to work. It's establishing the Office of Attorney General, of the U.S. attorneys. And then importantly, it's setting the number of Supreme Court justices at 6, but it is the big framework document. It's amazing. Like, if all we had was the Constitution, we have no idea what the federal judiciary was going to look like, really. It's with the Federal Judiciary Act of 1789 that we can begin to see what the federal judiciary, one, is going to look like at the founding, but two, it becomes the foundation that we build on from there all the way up until today.
And I love that. It really, reminds us that we look to the Constitution, but we also look to the other sources that inform the Constitution and clarify it and what had led up to the Constitution. So what the courts were doing before 78, the actions of the courts afterwards, Marbury versus Madison, and then the action of the other branches to really define how this works. We look at norms, we look at traditions, and we look at acts as well. So really helpful to kind of understand. You're not going to find it all in Article 3, but it's in there. It really is in there with all of the other pieces. Tom, thank you so much. That was a great class. Students, thank you so much. You were awesome in the chat. I'm going to stop the recording for a sec and then check any final questions.
Thanks, everyone.